Good morning, everyone, and welcome to the Court of Appeals, sitting today for the first time in its history in the M. Dolores Denman Courthouse here in beautiful Rochester, New York. Welcome, everyone. So the first appeals on our calendar this morning are numbers 166 and 167 in the matter of the people of the state of New York versus Phillip Couser. Counsel?
Good morning, Your Honors. May it please the Court, I'm James Hobbs on behalf of the appellant, Phillip Couser. I would like to reserve 4 minutes for rebuttal.
You may, sir.
There are two appeals in this case, and they present two different sets of issues. So I want to try to address both of them. I plan to spend a few minutes on the sentences for the trial convictions, and then I do want to address the problems with Mr. Couser's Alford plea entered after the trial was over. With respect to the first issue, the evidence showed that Mr. Couser attempted to rob a group of people who were walking together, and that he initiated this group robbery only through group-directed acts. He turned.
Is this a law question? The judge, it seemed to me, went through in pretty good detail why he was giving, consecutive and concurrence. And is your argument that even though he was doing that he was legally incorrect in doing so?
Correct. There is, as a matter of law, there wasn't evidence to separate and impose consecutive sentences under Penal Law 7025-2. Penal Law 7025-2.
But counsel, I'm sorry to interrupt you, but it seems to me if you have Ramirez from this court that says you can have consecutive sentences for robbing essentially a Brinks truck, right? And one is robbery of a guard, robbery of the gun. A second count that was run consecutively is robbery of another guard, robbery of a gun. Why isn't that analogous to this case?
It's not analogous because those two guards involved very separate uses of force. Essentially, in Ramirez, the defendant pointed the gun at the two guards. One guard immediately was subdued. He I believe, got to the ground and gave up his gun. The other guard engaged in a firefight. The other guard stepped away, tried to walk away, shot back, and there was bullets fired back and forth.
But why doesn't that go to Judge Piggott's question about, isn't this really a question of fact then?
I don't think so. The fact is, with respect to the attempted robberies, there was no dispute at the appellate division that, or at least the appellate division held that these acts were indistinguishable. That he pointed the gun at a group of people and he issued commands to that group of people. And that there was no individualized display of a firearm.
If he had requested or demanded that each person get to the ground, you would say that would create a
Potentially. If he had turned to one person and said, you get on the ground, then walked up to another person and said, you get on the ground, and so forth, then you would have distinguishing actions. You'd have basically a crime that's walking along a path and then branches, where it addresses one person and then addresses another person and then addresses
Well, what if the
person?
person in the back of the group didn't hear him initially, but he was speaking to the group
That's
and just followed what everybody else did?
I'm not sure. What we need to
That'd be a
turn on is
separate
what
act.
the number of actions that Mr. Couser took, not necessarily the behavior of the
Or
victims.
somebody hesitated?
If that then prompted an additional act directed particularly at that victim,
So they all
then
had
we'd
to,
have a different case.
because they all got to the ground at the same time, you're saying it's the same act?
In response to, I'm saying because he issued one set of commands on this record, we don't have any evidence that there were separate commands. If it took one person longer to get down on the ground, but he didn't take any additional act, I think we're in the same.
Counsel, does your argument not ignore the fact that the aggravating element of the robbery is the display of the weapon to the victim, and that there are separate victims there? Isn't that minimizing those separate acts and sort of according a group discount for the group?
I'd say two things. First, I don't think I'm ignoring the fact that it's a display of a firearm that aggravates this crime. In fact, that's one of the actions that's indistinguishable.
As to each individual victim who has to perceive the display of the weapon and the fear, the elevated fear that
Sure.
that causes.
Because Penal Law 7025-2 turns on the number of actions that the defendant takes, there are going to be a lot of cases where you have multiple victims but only one sentence. There's a case out of the appellate division cited in my briefs where a defendant drives his car into a police car that contains 2 officers. It's one action. It's 2 separate assaults, 2 victims. Sentences had to be concurrent because the defendant only took one set of actions against them. You could say that discounts the injury suffered, the fear suffered by the officer, but that's not the way the legislature asked us to look at these cases. The legislature directs our attention to the number of actions that the defendant took and whether or not those actions can be divided up. There's nothing on this record that allows us to divide up the way he pointed the gun. The testimony was he pointed it at the group, not that he pointed it at one person, then he pointed it at another, and so forth.
Then move us to the McKnight analysis.
The McKnight analysis, I believe McKnight is the case in which the defendant shot multiple multiple gunshots, right?
Mm-hmm.
So this is the way you have different outcomes with different sets of multiple victims. If the defendant takes one action against a group of victims, you're going to have concurrent sentences required. But if the defendant shoots multiple bullets, whether or not he intended to, intent isn't an issue. That's clear from McKnight and a number of other cases. The issue is the number of actions he's taken. And so if he shoots the gun multiple times and that results in multiple victims, then you can have consecutive sentence because the defendant took multiple actions. That's the way the legislature asks us.
You have convictions here for attempted robbery, which the appellate division then ran concurrently,
Correct.
and a robbery.
Mm-hmm.
Doesn't that suggest that they're separate acts? Doesn't there necessarily have to be something else to have a completed robbery?
There did have to be a taking, but that additional act is not sufficient under Penal Law 725-2.
And what's the case law support for that?
The case law support, I mean, there are multiple cases in which you have an additional act of taking, in which the sentences have to be concurrent. Laureano is a case out of the Court of Appeals, in which the defendant committed a manslaughter, killed a victim, and that act constituted the use of force necessary to complete to start the robbery. But then the defendant also took the victim's property. So that was
That's the
necessary.
same victim,
In addition,
right?
it is the same victim. You've got in Battles, or no, not Battles. I'm sorry, Ramirez. The other aspect of that case, there was an aspect in which there were 2 guards, but there was also a robbery of the guard and a robbery of the truck. Those are takings from 2 different victims.
But that, as I understand it, was a taking from one victim, but they had found that was also a taking from the company that the victim was driving for, right?
Well,
the other victim was the owner of the truck. or
True,
the
but there
owner
was
of
an
the fund.
additional act against them. There was the taking of the gun from the guard was the robbery of the guard. The robbery from the company, the separate victim, yes, it wasn't a person there in the literal human sense, but it was a corporate person there, and it did involve a separate act, taking money
But
from
again,
the
it's a
truck.
victim issue almost to me, that one, because you're saying the victim is the owner of the funds in the truck, but the act is exactly the same. The act of robbing those guards is the same act as robbing the company, because the company technically isn't there as a victim. They own the funds. It would be, somebody has my wallet and gets robbed, and they take my wallet, and I'm a victim. It almost seemed analogous to that to me.
I mean, I don't see that. It is a separate act of taking of the property from the truck. That wasn't the guard's property. That wasn't what was stolen. That wasn't what completed the robbery against the guard.
I don't mean to take you off your base, but you want to argue the
I
Alford
do.
part.
Thank you very much. I was about to try to turn to that, and I appreciate it. Okay, with respect to the Alford plea, after the trial was over, Mr. Couser entered an Alford plea to the charge of attempted intentional felony murder. He always denied that he committed this crime. That was basically the whole reason he went to the first trial, and he was prepared to go to the second trial to contest this again. The only reason the record shows for him entering this plea is to avoid the risk of another consecutive sentence.
But isn't it, this is an ineffective assistance claim, right?
I want to focus actually on point 3. I mean, the sentencing point that I make in points 2 and point 3 runs together, runs through both points.
But the Alford plea is an ineffective assistance claim.
The Alford plea on the record is deficient on its own, whether or not you find it ineffective, whether or not you fault counsel.
So how will we do that? If it's not ineffective assistance, you're saying you could still vacate and go back to a trial on the attempted murder charge. How would you do that? Give me the logic of that.
Sure. An Alford plea requires the court to ensure two things: that the defendant is making a voluntary and rational decision, a choice among his potential options at that point, and that there's strong evidence of guilt.
And what's missing here?
The idea that this was a rational, there's record support for this being a rational decision.
Well, there was a pretty extensive colloquy, right?
Not by the defendant. The
Well-
colloquy was conducted entirely with counsel. There was almost nothing said by the defendant on the
Yeah, but haven't we held repeatedly that as long as the counsel can make the statements, but the defendant has to be asked, do you understand this? Is this what you want to do? And didn't that take place here?
That didn't take place. There was no questions to confirm that he was that he understood the proceedings. No question to confirm that he wasn't under the influence of any drugs or alcohol, hadn't been made any threats or promises. There were no questions to confirm that he understood the trial rights he was waiving. None of that happened. But then also we have on the record at best, oversimplification of what the risks of a consecutive sentence are at trial. I think it's a flat wrong, but at best, it's an oversimplification. There was nothing to confirm that he understood the consequences that might occur at trial and the fact that he might have an argument for concurrent
Well,
sentence.
there certainly was a full discussion of what the proof was against him and the likelihood of his being convicted on a retrial and all that. Doesn't that factor into it?
I suppose that's a helpful
I
fact.
guess
that
the
discussion was
problem
helpful.
I'm having is how to distinguish between the ineffective assistance claim.
Mm-hmm.
All right, I get that. He gave him the wrong information. That's your argument. The problem there is that you've got the trial judge and the Fourth Department. Even if we overturned him, is it ineffective assistance if the Fourth Department agreed with his underlying analysis and logic? So then you get to the Alford claim.
Mm-hmm.
And in the Alford claim, if it's not ineffective assistance in how he gave his plea, then I'm having a hard time seeing that it's not KVI, knowing and voluntary and intelligent.
It was the court's obligation to ask whether he understood the risks that he would receive.
So it's not
after
ineffective
trial.
assistance of counsel, it's the entire proceeding, including
That's
the
correct.
court. Okay, that's your
That's
argument, I see.
I see my time's up, but just one case in which is similar to this is People versus Hill. It's a 2011 decision from this.
Right,
this
but that's
court.
the only one that seemed to be going that way in terms of the analysis. It seemed like all the other appellate division authority, well, I should say all the other appellate division authority kind of favored you. Hill seemed to be going the other way in the Second Department case.
No, the Court of Appeals decision in Hill, though, was one where the defendant was not asked whether he he understood that he was making a choice to avoid a harsher consequence
Sure.
after trial.
Thank you, counsel.
Thank you.
Counsel?
Good morning, may it please the court. Kelly Wolford on behalf of the people. First, I'll address the consecutive sentence issue because I do think that it directly impacts the Alford plea situation. Your Honor, I do agree that the argument made by the defendant here is in fact giving a group discount for the robbery or attempted robbery of 5
But
separate
that
individuals.
really wasn't your argument, was it? I have a little difficult time, and maybe you can clarify it for me, but it seems that you're arguing that there's a different analysis between the first degree and second degree murder. And that in your brief you argue that the first degree murder is, we should be looking at the mens rea, which is different than the way I read Loreno for consecutive sentences in the test there. But with second degree murder, we should be looking at the actus reus, at the act itself. Is that your argument, or are you saying something else?
With respect to the Alford plea and whether or not the sentence for attempted murder first would have run consecutive, it's actually a two-part argument. One would be that there are two separate actus reuses with respect to intentional felony murder, which does not exist in felony murder under Murder 2, where the felony supplants the intent or the mens rea element, where you can't have felony murder under Murder 2 without the underlying robbery. When you have Murder 1, however, you have the felony of, in this case, robbery, but then you have a completely separate act of intentional, or here, attempted intentional murder. So you have to have the intent to commit the robbery or attempted robbery, and then you have to have the separate act of actually intending to commit the murder. So we have two different actus reuses where if you go back to Murder 2, where there's no intentional murder element to that crime, and you have no mens rea for the murder, it's supplanted by the underlying felony, we have a separate situation. So there's only one actus reus in murder second, where there's two in intentional felony murder.
I've never seen that argued anywhere.
That's why we're here,
This
I
is
think.
something new. It's creative, I gotta give you credit there, anyway, I gotta give you credit.
If I'm nothing else, Judge, I can be creative.
You gotta give somebody credit for that.
Ms. Wolford, going back, I know you want to talk about the beginning of this thing. When you look at what happened, in your view, could the judge have made these all concurrent?
He could have.
So this is all discretionary.
Absolutely.
And we've got to decide why a judge would say, even though you've got these people on the ground and you're doing what you're doing, and you only took the purse and the gunshot grazed one person, he can parse these out and add up to 48 years as opposed to what would be a much smaller, I forget what, if they're all concurrent, would it be about 15?
He could have done 20, if he got the maximum sentence on the one completed robbery, he could have done 25. He was given 18 on that, and then the judge then took the rest of the time and kind of parsed out per victim a different sentence. That was, each one of those sentences was less than the maximum that was available for each of the charges.
It just seems strange to me that, if we have our predicates and our persistence and all of those make sense, but here we're saying, because of what you did in the park, I'm deciding that you're gonna do 48 years for stealing a purse and I don't wanna say nicking somebody with a gun. I mean, it was not a nice thing to do. But it just seemed like a broad discretion on the part of the judge. And you're saying that yeah, they can do that, or they can make it concurrent.
Well, and I think ultimately the first issue we have to get by is whether or not legally he was authorized to impose consecutive time. And in this particular case, he was legally authorized to impose consecutive time. And if we go back and we take a look at the record and we see what happened in the park that night, to say that there is only one, in essence, what defendant's arguing is there's only one robbery. There just happen to be 5 people there.
Well, no, not really. I mean, what he's arguing is that you could have charged him with another kind of attempted murder, but the way you charge attempted murder here, the way you charged him here, you could have charged felony murder in a different way, or you could have charged him with intentional murder and not felony murder. And if you had charged him with intentional murder and not felony murder, then there would be no question of the stacking here. It would be a straightforward. But that's not the way you charge him. It's because you charge a felony murder that we're in the situation that we have to look at the underlying felony and see if that in and of itself can be distinguished. That's why we're in this situation.
Okay, so two separate issues, I think, Your Honor. The one with respect to whether or not the 5 counts of 1 completed robbery and 4 attempts can be run consecutively to each other, and then the separate issue of whether or not that intentional attempted felony murder can run consecutive to any of those. Now, just briefly, I'll come back to your question, just pick it, but just briefly on the attempted intentional felony murder case, that charge was the one that they hung on, and is ultimately the Alford plea is over. At the point in time when he makes a decision to plead to that charge, we are at the point in time where we have to retry that case. And I do understand that during the first trial, we did not specify the underlying robbery or attempted robbery that was the predicate for the robbery. However, we're facing a second trial now. And at this point in time, we can fix that. We can specify that it was Mark Lewis who was the attempted robbery victim, and that he was the one that was shot, and then we would avoid the problem that he's arguing now without a doubt. We wouldn't even have to get into whether or not everything was consecutive, because the shooting of Mark Lewis and the robbery of him would clearly be consecutive to the theft of the purse.
But we're talking about felony murder here.
Well, it's intentional felony murder,
right.
And he was convicted of attempted robbery of Mark Lewis, okay? So if Mark Lewis is the person who shot, and Mark Lewis is also the victim of the attempted robbery, and that is clarified to the jury on retrial, that can run consecutively to the time that he was given for the completed robbery of Julie Belknap. That is clear, and we can do that on the second trial, and we're not bound by what happened during the first trial. So actually the attorney was 100% correct in giving the advice that he could get consecutive time if he went to trial, which then takes away the ineffective assistance claim. So the Alford plea, besides the fact that we're all here today still arguing about this years later, clearly the attorney was correct in giving him the advice he could face consecutive time. And then the decision was rational to take the plea to the minimum on that charge and run it concurrent with the time that he was already sentenced to. Now, going back to the robbery and the attempted robberies, we have 5 people who are laying on the ground. Every single one of them testified that the defendant waved his gun at all of them. Now, as I hear defendant's argument, if he stopped at you, and then you, and then you, and then you, and then you, then we have 5, those would be 5 robberies. Those would be consecutive time because they're distinct acts. I pointed at you, and I stopped. I pointed at you, and I stopped. But here, we have 1 robbery because he does this. Instead of saying, man in the tie on the ground, woman with the earrings on the ground. This is what he's saying separates this case from Ramirez. The fact that it was a continuous pointing of the gun. Every single one of those people says the gun was pointed at us as a group. It wasn't pointed at one individual. Julie Belknap says it was pointed right in her face. Clearly, it's pointed at Mark Lewis, who's shot in the head. Every single one of them who came in and testified said it was pointed at the group, that he was waving it around.
So
that
counsel,
doesn't make
it wouldn't
it
matter
one
how
robbery.
many people, what if there had been 10 people and then each of those were run consecutively? We have here, that would net this guy maybe 50 years or more in jail just for a robbery when, nobody died here. I agree with Judge Piggott. This was
Right.
a horrible incident, but nobody died.
Well, and Your Honor, with all due respect, the law in this is really kind of messy. And part of it is because it does come down to some very, very specific factual determinations in each trial.
Well, doesn't it ultimately come down to the second prong of the Loreno test, which is the separate and distinct prong? It just ultimately comes down to that, right?
Whether they're separate and distinct acts
Right.
between the, yes.
Yeah.
And here we have.
But the problem I had was that's not really the way I saw you arguing it. I thought you were arguing it on the whole mens rea first degree murder versus second, and you really weren't arguing it that way.
I think that argument was an attempt to distinguish it from the cases on the second degree murder cases. And like I said, there's 2
And that's where all the
arguments with
appellate
respect to
division's
that.
authority is, so that's why you were doing that?
Right.
I see.
And then if we go back to the robbery, quite frankly, I think the appellate division got it wrong in running the one completed robbery consecutively to the 4 attempts, and then running all of those concurrently, because I think that there was record support for the judge's decision to run those terms consecutively, given the facts as he found them, or as the jury found them at this trial.
How long did this whole thing take? From the time that he accosted these 5 kids, and I shouldn't call them kids, but to the...
It took a very short period of time. All of them say we don't know exactly how long, but all of them will say it's very quickly.
Does that trouble you at all, that because the judge says, because you did this with this one, I'm giving you 15 plus 5, and on this one I'm giving you 10 plus 5, and all this adds up to 48 years in jail?
Right. Well, what we
Does
don't
that
want to
bother you at all?
discount, Your Honor, is the fact that in this case, that would be whether or not he abused his discretion in his sentencing, and that would be a factual issue, not the underlying legal issue, which, quite frankly, is very important to the state, not because of the facts of this case, but because it really does affect consecutive sentencing law across the state, whether or not under circumstances like this, it is separate acts. Because there can be much more significant things that happen to people under these circumstances.
Like what?
What if the person at the end of the line had a heart attack because she was so scared?
We'll talk about
I
that
have no
later.
idea why that can But there's many circumstances that I can
But you
foresee.
could charge, to pick up on what Judge Fay was saying, you decide how you want to charge these things,
Right.
and those things occur. But
Right.
it just seems to me that, and I don't mean to take this lightly, but I mean, if you're putting somebody away for 50 years because, as nobody knows, I mean, a 5 or 10 minute thing where nobody died, and in fact,
Right.
the gentleman that was shot, I mean, it was a grazing.
It was a grazed one.
and
Well-
That doesn't that trouble you?
It doesn't trouble me, Judge, because basically what can happen here is ultimately that is the sentencing court's discretion. And here, he could have received the minimum on each one of those charges, and there's no mandatory consecutive, it's discretionary.
So what if
Minimum.
there were 100 people? What if he walked into the
Well-
mall or the train station or the grocery store and waved it around and said, okay, everybody down, okay?
Well, and I was thinking of that, Your Honor, because I was thinking of the circumstance where we've seen in the movies where somebody walks into a bank, there's a whole lot, all these people are here, but I want to rob you. I want to rob this teller. Everybody else is closed, and I walk into the back and I say, everybody on the ground, but then I go right to you. And I stay with you, and you're the only focus of my attention. When I've got your money, I leave. Completely separate from what happened here, where during this whole event, he's saying, on the ground, I'm gonna kill every one of you. He steals your purse, and he shoots you in the head, and he's waving the gun around at everybody who's very close to each other. If those people had been behind him in the park watching, there
But
wouldn't
what
be a
if while
robbery.
he's at the teller window, he says, and all of you behind me, give me your wallets while I'm doing this?
Then he has separate robberies.
Your reading of the statute, though, just to go back to the fundamental question, which is a question of what's just, is a life sentence, right? Isn't that your reading of the statute, that we're at, because it's intentional murder, because it's felony murder, it's a one, so it's murder one, so we're talking to life, right?
Correct.
Okay, so we're back to Judge Pickett's question, which seems to be the heart of the question. It is a court of appeals, so is that just?
Well, with respect to the felony murder conviction, it's a mandatory life sentence. He got the minimum for his record on that.
So
on
would that
term.
explain the reasoning behind going for that as opposed to murder two when he would have got capped at 25?
As a prosecutor, there's many reasons why you would do that, and it would depend on the circumstances of each case. It wouldn't necessarily be to get life on the end, although that is obviously a factor if you feel someone deserves that. But in the same vein, we have an individual who every single person testified that he brandished the weapon. They heard him cock the weapon. That it seems from the record that Mr. Lewis was slow to get down, and as he's getting down, he gets shot in the back of the head. He's lucky he flinched, and it's a graze wound because he's clearly shot in the back of the head. And then, depending on which, there's a little bit of a conflict in the testimony whether the purse was taken before or after, but quite frankly, after that, he takes off. So I think what ends up happening.
You see what I mean, though, by
Ms.
almost
Wolford, do you want to move to the Alfred plea?
I do want to move to the Alfred plea just quickly. I think we've addressed some of it with respect to I don't believe that counsel was ineffective or counsel gave wrong advice that undermined the voluntariness of the plea. I think the record is very clear. It was a knowing, intelligent, and voluntary waiver. And that although it's an Alfred plea, which I know is not necessarily beloved by the court here did the right thing in how it went through the entire factual colloquy and the entire legal colloquy. And ultimately, the record's very clear that he understood there was a great possibility of him being convicted of intentional felony murder after trial based on the original trial results.
What did he ask the defendant? What did the judge ask during that colloquy of the defendant? Because he says that's, on this part of his argument regarding the Alfred plea, that's where he says the judge, the colloquy is defective.
Well, and I think that's actually not what he wrote in his brief. There was a completely separate argument in the brief that has nothing to do with that. But I think what does happen.
I think he did say that the colloquy was not good enough. And I think he did say it's involuntary because you don't have anything in this record to show that this defendant understood the consequences of the plea. But anyway, you tell me why the record is good enough.
The record clearly goes through, and we're talking about whether or not, he has argued whether or not they understood that he could get consecutive time. That's been the continuous theme. It is written in, the court goes over that, and it goes over that with counsel. Defendant is present with counsel. There is clearly discussion back and forth.
But does the record show he understood otherwise all the other rights that he was forfeiting as a result? He was waiving as a result?
Yes, it does sufficiently.
Where does the judge ask of that? Or where is it in the record?
I'm sorry,
that you see
I'm going to need to look at the record because that was not actually argued. At no point in time did he argue that there was a Boykins right violation. There was no argument. The argument was completely focused on whether or not the...
You think it's not preserved?
It's definitely not preserved, and it
preserved.
was completely not argued until this morning. So I apologize, I don't have that fresh in my head. But he did go through the part that was argued, which was the understanding of the defendant as to the strength of the people's case and his likelihood of conviction after trial, and the defendant making a voluntary decision, even though the defendant had maintained his innocence with respect to the intentional element of the attempted murder, that was covered during the Alfred colloquy. And as we argued in our answer to point 3, Alfred, by its nature, the defendant's not admitting his guilt to all the elements of the crime. So the fact that he negates an element there, that's expected in an Alfred plea, but he then says, I understand that I would probably lose in that argument, and I'm willing to take the consequences anyway, given the beneficial plea bargain.
Thank you, Ms. Wolf.
Thank you.
Mr. Hutt?
Mr. Hobbs, isn't that true? From your own experience, sometimes you just don't want your client to say a whole lot when they're in front of the court.
You may not want them to say a whole lot, but that doesn't mean that that's the right way for it to be done. That may mean you have an involuntary plea. I mean,
but that doesn't rise to the level of motor proceedings error, does it?
well, it is an error that this court can reach as a matter of law. I don't think it's ever been characterized as a motive proceedings error, but in cases like Lopez and Mox and so forth, if there's a defect in the proceedings, if there's a defect that shows that the plea was not potentially fully understood,
But how do we
then it
know
can be
that?
reached.
Wouldn't a 440 suit the defendant better in a situation like this to explain why, in his view, his lawyer was somehow ineffective?
No. On this record, the explanation of the sentencing risks, if he went back to trial, were stated on the record, and it was erroneous or at best oversimplified. And there was just not a single question asked to clarify that with the defendant. There's not a single question asked if he even understood the advice of counsel that he received, much less whether or not it was actually.
But we don't know that. That's my point. In other words, is he going to say that, or is his lawyer going to back him up, or is he going to? We discussed all of this, and I made it very clear to him, I don't want to hear a peep out of you, because I'm going to handle this with the judge. And Alfred's a complicated thing, and so we're going to run through it. Do you have any questions? And then at the end, he didn't seem to be particularly upset with the guilty plea.
It's the court's obligation to ask these questions. The same thing could be said of a case like Mox, where the counselor, the defense counsel, answered the questions about the defense that was being waived and said, yeah, we're going to waive that defense. That's fine. This court held that that's not enough. You need to ask the defendant if they know that they're waiving that defense. Similarly, I think the same thing is true here. He needed to ask Mr. Couser whether or not he understood what the sentencing risks were if he went to trial, and that he was making a rational decision to avoid those sentencing risks. There's just no, the attorney gets up there and says it, but we have no idea whether Mr. Couser understood.
That's the only part that's defective. She is correct then, that's the only argument you're basing this on about the plea, this part of your argument.
I believe that that's
about the plea being involuntary.
That is a fundamental defect in this plea, but the plea on its whole is deficient, and I made that argument both in my opening brief and then more fully in the reply brief. I cite Boykin.
The question is, though, I think this is an important question because it's either a pure legal question or it can be enhanced by the record. And because your argument is the record's inadequate as to the plea, that would favor a 440. But if it's a pure legal question on the questions that were asked, and there has to be some deficiency in what the defendant was asked to respond to by the court, particularly, or offered proof that was failed to be offered by counsel. One of those two things had to happen. Is that correct? Is
That's
that what you're
correct.
arguing?
It does have to be
So it's a pure legal
defective.
question. You aren't arguing there's some place that we can point to in the record. You're just saying there's a deficiency in the record that shows that the legal question wasn't addressed.
Right. The deficiency is at least as clear as it was in Serrano, in 1965 case where this court held an Alfred plea was inadequate, and in Hill, where this court held the same thing. It's also at least as deficient as Lopez and Mox.
Could you respond to her hypothetical about the bank?
The bank. The bank involved a robbery of the teller with a bunch of people standing in the background.
Walk in, show the gun, shoot the gun, whatever.
I'm not sure
Display it.
what the crime against the people in the background are. There's no attempted robbery being charged there. The idea was that there wasn't any attempt to rob those people. So is it menacing? I'm not sure what the crime would be there, but you'd have to look at what the elements of that crime would be and then look at those. I do want to respond to the idea that, if he had paused at each person and made a separate threat to each of them, potentially that could distinguish the crimes, but this is where the law gets fuzzy. How fine-grained can we get before we start distinguishing separate acts? And I admit that is a difficult question under this law, but it is the question that's put to us, and when it's enough is a question for a different case. This case,
Isn't that the
there's
question,
nothing in the
though,
record.
really for the trial judge, who heard all the testimony about the acts and listens every day to this and understands the situation from sitting through the trial? And again, going back to, I think, Judge Piggott's point, isn't this a question of fact more than law?
I don't think this case presents a question of fact because there was no such distinguishing evidence.
But
And
you're
when you
saying
look at
it's fuzzy, and I think fuzzy to me means you really have to parse, I think as you're saying, the facts of the case, and did the person pause, did they move on? If I'm a trial judge sitting through the testimony of however many victims you had here, I certainly would think I have a better basis for doing that in an appeals court looking back as a matter of law.
What I was suggesting is that it could be fuzzy if there was evidence of pauses and evidence of separate threats to carry out the robberies. Here, there was no such evidence. The reason that the sentencing court gave for distinguishing these sentences and imposing different sentences was not about separate acts that Mr. Couser took particularly. They were about how the acts impacted each of the victims. The fact that one person had property taken accounted for one. The fact that Mr. Lewis got shot after the robbery was complete, which was clearly held to be not part of this robbery, and supported by this court's decision in Rodriguez, that was his justification for heightening that sentence. The explanation for the 10-year sentence on one of the attempted robberies and 5-year sentence on the attempted robberies, I don't understand. There doesn't seem to be a good explanation now.
Thank
None
you.
of it was, separate acts.
Thank you, Mr. Hogg.